Hi, folks. We are now moving on to handout 14, which gets us into the second half of the course about wills, trusts, and estates. The whole point of this is to determine what happens to someone's property when they die. In English law, this was a very important reality because everything was based on bloodlines, everything was based on family, who could own property, who couldn't own property, who would receive it. Your status in society was based on who your parents were and your grandparents were. So it was a very, very constantly brought up subject within the British courts about inheritances, about titles, of nobility, of all different type of things. And over 1,000 years, the English worked out an incredible system for handling the transfer of wealth, power, and social custom from generation to generation. The basic reality of the English system, which is still the system in Rhode Island. They have begun to change the system a little bit in Massachusetts by adopting the model probate code, and we'll talk about that at the end of this lecture. But in Rhode Island, we are still using the basic system that the colonists brought here when they came from England in 1636, and it is based almost entirely on blood relationships. The only thing that was important in British society was who you were related to by blood. Now, some of the things that we have to talk about. We have to come to grips with the idea of an heir at law. Um, Most people would jump easily to conclusions, say, "Oh, you're an heir; it's your children or it's your grandchildren." Well, that could be if you happen to have children and grandchildren who survived you. But if you did not have children or grandchildren, either because you had never had children before you died or because all of your children and or grandchildren died before you still have heirs. Everyone has heirs. So the question then becomes, how do we determine who are your heirs? And the only way we know that, we don't know that when you're still alive, because there is always a possibility that somebody who is younger than you or would be in line to inherit would die before you do. So the concept of who is your heirs took on great importance among the British and among the court system. I have a chart called a table of consanguinity, which is a fancy word for blood relationship that I've posted to Blackboard. And if you look at that, it gives you a basic outline of how the British courts and now the Rhode Island courts will determine who are your heirs. And the basic definition of an heir is the person who is designated by law to receive the property of one who dies intestate. Now, the other thing that we need to talk about here is testate and intestate. There are only two ways you can legally die in terms of your estate under Rhode Island law. One is intestate, which means you did not make a will, or if you made a will, you destroyed it, revoked it, and at the moment of your death, you had no valid will, which means that your property, it's not going to go to the state, it's not going to escheat, it's going to pass to your heirs at law, whether that's what you wanted to have happen or not, because you did not make provisions for what would happen to your property. The state has a wonderful system that determines this is what will happen, and by operation of law, ownership by your heirs at law come into being. Now, if you die testate, that means that you did, at the point of your will, have a at the point of your death, have a valid last will and testament stating your intentions. And once the probate court has reviewed that, has determined that it is a valid will and that it is your last will, then the court will go about to see that your intentions are carried out. So instead of having the state determine where your property is going to go, by use of a will, you get to make that decision, you get to make that determination. Before we go on talking about wills, I'd like to talk about some of the rules concerning heirs at law, and they are called generally rules of descent. Now, when we start talking about heirs, there are two different lines that we talk about. So let's create an imaginary man named Harry. He is going to be our example, and two things can happen. If Harry has children and grandchildren who survive him, then we are looking to see how his property is going to descend. These are his descendants. They come after him in time, and when we draw charts of these things, they tend to be drawn showing that these people are below Harry. There are also ancestors, people who have preceded us. And if you have no children, you have no grandchildren who survive you, then we look backwards up the chain to your ancestors. Now, your most immediate ancestor would be your mother and father. But the normal rules of human life are such that normally by the time you die, unless you die of disease or accident at a premature age, usually your parents have predeceased you. So if you pass away with no children, grandchildren, great-grandchildren, no descendants, we start and we look for your ascendants. We go back up to the first generation and we see, all right, they're your parents. Your parents are already dead. So what do we do now? Well, we look and see if they had any descendants. Your parents' descendants would be your brothers and sisters. So here, if our Harry had no children, had never had children, had no descendants, he passes away. If his parents are alive, his parents become equal heirs at law, so they would equally split his property. If only one of them survived, the one would receive all of his property. If neither of them survived, then we have to go and look to their children, their descendants, who would be Harry's brothers and sisters, or if he had brothers and sisters who predeceased him, leaving children, it would be his nieces and nephews or great nieces and great nephews who would split his property in various ways. All right. Under Rhode Island general law, and Title 33 is the title that deals with wills and trusts and inheritance and probate court. So, important title to know. Those of you who are paralegals dealing in this area are going to come to know big chunks of this by heart. And it is a difficult thing because, again, even much of our statutory law comes from the early 1800s and has not been amended. So very often when I'm going to look for answers in Rhode Island, I get as many questions when I'm done than I get answers. It's a very cumbersome process. There is a bench bar committee of attorneys who practice in the probate area. They have tried for years to get the legislature to make amendments, to make changes, but apart from making small little changes here and there, our legislature has been fairly resistant to changing this system that has been here for nearly 400 years. So under Rhode Island General Laws, Title 33, Chapter 1, Section 1, it defines your heirs. They are first of all your children and descendants from your children or through your children. If no children, then it would be your parents. If no parents, then brothers and sisters. If you have no descendants, no parents alive, no brothers and sisters, no nephews and nieces alive, then we go back to your grandparents. And from your grandparents, we go down through your aunts and uncles, your cousins, second cousins, and it goes on from there. If you pull up the chart that's on Blackboard, open it up, you'll see the kind of progression as this gets further and further out. Rarely do we go beyond one or two circles out. Somebody would have to live to be very, very old and have had to have extremely unlucky relatives for us to be looking 4 and 5 circles out for their heirs at law. If no blood relatives, all right, if no blood relatives, no kindred, no survive, then your husband or wife is entitled to your estate. Now, this is interesting. Legally, your husband and wife are joined to you by the virtue of marriage. However, under the old English inheritance laws, they were only good friends. They were not blood relatives. They were not necessarily your heirs. So only after your entire family has been wiped out and does not exist, at that point, we say, oh, well, maybe we should leave it to the spouse if they survived you at time of death. All right? If you have no family of your own, no blood relationships of your own, if your husband or wife predeceased you, but left kindred, then it can go to the heirs of the husband or wife. Now, having just made these horrible defamatory comments about the status of spouses in Rhode Island, there are some bones that the legislation throws to a spouse. A surviving spouse has an automatic life estate in all real property of the deceased. So if the deceased owned land or buildings or condominiums, the surviving spouse has an automatic life estate, which means they get to control it, they get to have the rents, they get to use it for their lifetime. And that is true even if there were descendants, even if there were heirs at law. So the life estate is an absolute. So even if the husband has no will, has children, and maybe even children from a prior marriage, which makes things even more tense and more difficult at the time when the spouse passes. So let's say our little man Harry, he had been previously married, had 3 children from a previous marriage, and then he dies with his second wife being his wife at that point in time. If he leaves no will, she gets a life estate in all his property, even though he has children, even though he has descendants, and even if he had no descendants, she would still keep that life estate over any of his brothers, sisters, aunts, uncles, cousins, whatever. So that's a very important reality that is given to spouses in Rhode Island. The descendants of deceased heirs shall inherit what their ancestor would have taken. In more modern language, we call this a right of representation. So let's say that our man Harry dies with no spouse, and he had 3 children during his life. 2 survive him, 1 died, and the child who died left 3 children, so Harry has 3 grandchildren through that child. The 2 children of Harry would take part of his estate, and the child who died, their children would take a representative share. So, and one of the things we need to tell you is that when we're dealing with heirs at law, at each level we divide the property equally. So if Harry has 3 children who survive him, then they will divide the property into thirds. Each will take a third. In our situation here, Harry has 2 children who survive him, 1 who died, but that one who died left children. Those children, those grandchildren, would take their parents' third. They would represent their parent in the probate proceedings in the estate. So, and that's what the statute 3317 is trying to say. And again, in modern terminology, we have shortened that to just call it the right of representation for children of deceased parties. 3318 is a statute that has gone through significant change during my legal career. The English law was very clear. Any child born out of wedlock, that was born because of an affair between the father and the mother, was a bastard. They were not considered to have any privilege, any rank at all. They were considered illegitimate. They could not inherit from either parent. They had no social standing. They had no right to inherit property, titles, or anything from either of their parents. In the early 1970s, our Supreme Court overthrew the illegitimacy statutes of one of the southern states where they would have worked to keep the father of illegitimate children who had been killed in an industrial accident from collecting his workers' compensation award just by virtue of the fact that he had not married their mother. And when that got up to the Supreme Court, they said that under the 14th Amendment and under our Constitution, that was a denial of due process and equal protection, that you cannot create categories of children based on their birth, just as you cannot create categories based on race or ethnicity or national origin or religion. And so therefore that law about the workers' compensation was overthrown, and the children were allowed to receive the benefit. Very quickly after that, a number of states, including Rhode Island, changed their laws. So now that it does not matter if you are the legitimate child or not, as long as you can prove you were the child, either by having that parent named on the birth certificate while you were alive, or by virtue of genetic testing, you are entitled to inherit as one of the children of the deceased parent. There's an interesting thing. And it took several clauses for them to describe what would happen here. But the basic idea is something called the Slayer's Statute. And what the Slayer's Statute says is that if you are somehow responsible for the person's death, you cannot receive any benefit from their estate. And the responsibility doesn't necessarily have to be criminal responsibility. Certainly, if you murder somebody, if you murder your grandfather or your grandmother, you're not entitled, or your parents, you're not entitled at that point to inherit from them. You are basically treated as you did not exist. But it gets even touchier than that. When I was a young lawyer, I worked in a law firm where one of the attorneys was a guardian for some children, and they had a mother. I knew their father had died, but they had a mother, and normally when one parent dies, the other parent is the natural guardian. You don't have to go to probate court. You don't have to open a guardianship. But here there was a guardianship, and this partner that I was dealing with handled all the finances for these children, and I really couldn't understand why that would be. And finally one day he explained to me that the parents had been coming home from a party. The mother was driving. She had been drinking. There was a car accident. The father was killed. She was never criminally charged for drunk driving. But when it came time for the probate court to determine inheritance, they determined that she was responsible for his death, so therefore she could not inherit. Anything that would have gone to her went directly to his heirs at law, who were his children, but also her children. And until the last one of them became 18, she now had to deal with this guardianship and this guardian who controlled the children's money, not her. Rhode Island 33.2.129 deals with simultaneous deaths. It often happens that people who are connected to each other as heirs at law, or as spouses, or as people named beneficiaries in each other's or one another's wills, die in such a way that it's difficult or impossible to determine who died first. And of course, if we don't know who died first and whose property goes where and how does it happen, and if these people happen to have different heirs at law, if you were going to make one of your cousins a partial beneficiary of your will if she survived you, if she survives you, then the property's going to her and her children or whatever. If she doesn't survive you, it's going somewhere else. So it very often will be determinative who's going to get what when we settle everything out, but it's sometimes very difficult to determine. So the statute was created to basically say that if two people die simultaneously, we split the estates and we pass them as if each one of them had died first, which becomes very cumbersome and sometimes almost impossible to determine exactly what does that mean, particularly if it's spouses who have joint accounts and beneficiary accounts. One of the wonderful things about this statute and about much of this law is that the laws that allow us to create wills also allow us to rearrange these rules. So in a will, it is possible to state that if the parties die, like a husband and wife die in a situation where we can't tell who died first, we presume that one died first and the other one died second, so we know what order to probate the estates in. And very often we would look to set that up, particularly if there are tax issues involved or if there are issues involved with children, with second marriages and that type of thing. We would try to write that in the will in a way that most reflected what the parties wanted to have happen. All right. Degree of kinship is determining the closeness of a blood relative to determine who would inherit ahead of other people. Intestate, as we said, means dying, the state of dying without a valid will in place. Testate means just the opposite. You have a valid will in place when you die. Your descendants are parties born through you, your children, your grandchildren, great-grandchildren. All right. Issue is another older word for descendants. So parties who are born through or because of the deceased, and again, that would be children, grandchildren, great-grandchildren. A will is a legal document executed with proper formalities that states the intentions of the deceased as to the disposition of their estate and their property. Rhode Island General Laws, Title 33, 5.1-12, deal with the execution of wills and tell us how and when and who in Rhode Island can make a will. Now, one thing that I have to be very clear about is that The right to make a will is actually not a right. It is a privilege granted to you by the legislature of your particular state. The English courts were very hostile to wills because they had this whole social, economic, and political system set up based on inheritance. They did not want people to have the right or power to play with that, to muck with it, to alter it. So they, for the longest time, wills were treated with some, I don't want to say scorn, but with a kind of jaundiced eye by the courts. And if you didn't do everything exactly, completely, totally, perfectly right, the courts would have no problem saying, oh, that is not a valid will. We'll just follow the laws of inheritance here. So, having said that, it's very important that if you're in an office, if you're in a practice dealing with wills, that you know the rules for creating them and know and watch to make sure that they are scrupulously followed when clients come in to sign their wills. The first thing is, who can make a will? Under Rhode Island law and under the law of most states, you must be, first of all, 18 years of age. You have to be an adult. So it doesn't matter if you can be a child, movie star, TV star, rock star, have billions of dollars. You cannot make a will until you turn 18. Making of wills is reserved for adults and adults only. You must be of sound mind. Sound mind here is not a psychiatric standard, it is a legal standard. And the legal standard has two basic prongs. You must know that you are signing this paper, you're dealing with this document that's going to determine what happens to your property when you die. You must know who your natural heirs are. So if you have children, you must have some idea that, yes, I have children, and by signing this piece of paper, I'm going to alter what happens to them when I die. And you must have a basic idea of what your estate is. You don't have to know it down to the penny, to every bank account number, to every piece of property, but you must have some idea of what your property is. If you understand those three things and can communicate them, then you have a sufficient mental capacity to make a will. We had a very interesting case when I was a young attorney, first going into private practice, where a woman who had been under a guardianship all of her adult life. Now, we will talk in the next handout about the probate court and handling of guardianships. A guardianship is imposed on someone who is believed not to be mentally able to handle their own affairs, to take care of themselves. And so somebody is appointed by the court to take care of their property, and very often can also have the power to take care of their living situation, make medical health decisions, basically be in control of their life. So you would think automatically that somebody on a guardianship would not have the capacity to make a will. However, this woman, she had been put under a guardianship when she was a young adult by her parents. The parents died, and a woman remained her guardian for many years. She was now in her 60s. The caretaker was probably in her 80s. There were several other people who had come in to help her through her life and do things. And she understood enough to know that, and her parents had left her a tremendous amount of money. She knew enough to know that if she didn't have a will, her parents' money was going to go to her cousins and to other people who she didn't particularly like. And she really wanted to give part of the estate to the people who had been around her all her life and had taken care of her. And we talked about it. We banged it back and forth between us in the office, and we finally decided that she knew enough. That even though she was under a guardianship, she knew enough about her estate. She knew enough about her heirs. She knew enough about what she wanted to do to be of sound mind. So we proceeded to write up a will, have her sign it. We had it witnessed, and one additional thing we did, which was 30 years ago and was rarely done then, is we also videoed it so that the court could see exactly what was happening and get a good sense of what was going on with the will. We'll talk about that a little bit later, about videoing and where the law stands with all of that. So, in order for a will to be valid, first of all, the testator must meet these certain requirements and have what we call testamentary capacity. Then, the will must be properly executed. Under Rhode Island law, a will must be in writing. It does not have to be typed, but it has to be in writing. It has to be signed by the testator. Testator is the term for a male who makes a will. A testatrix is a female who makes a will. All right, so the testator, testatrix, they have to sign the will. However, they must sign it in the presence of two witnesses. They must also publish the will. They must make a statement saying that this is my last will and testament. I know that's what it is. I am signing it, and I want you to be my witnesses. Once that is done, the witnesses must sign the will, and they must do that in the presence of the testator and in the presence of each other. If any of these parts of this little ceremony are missing, the will has not been validly executed and could be thrown out and could be found by the probate court to be an invalid will. And of course, the only time that that is determined is after the testator or testatrix has died, so now it's too late to go back and fix it. So one of the things that happens in our office is that we have a set procedure for doing wills. We are very hesitant about letting clients take them home and witnessing themselves, and that happens very often, particularly if clients are going away on a trip and they want a will done quickly, and they'll say, well, just email it to me and we'll get our neighbors to witness it. Well, we have no guarantee at that point if it's done correctly or not. So we really put the pressure on the clients who come into the office. 99.99% of the time, one of the attorneys sits in on the will signing and one of the paralegals, and we go through this process to make sure that everything is done exactly according to these rules. One of the reasons we also do that is there is an exception to the hearsay rule, and there's something called the business records rule, so that if it ever came up that somebody was challenging the will, we could sit there and say, well, I don't particularly remember these people. I witnessed 500 wills that year. However, the practice in our office was for 30 years that we did it this way. We never varied from that. So I have no trouble testifying, Your Honor, that I am absolutely certain this will was done this way. And under various evidentiary exceptions, that type of testimony is allowed, and particularly allowed in a wills contest. One of the interesting things about wills is if somebody is challenging the competency of the testator or testatrix, this is one of the few times where you do not need expert testimony. You don't need a psychiatrist, a psychologist, or a medical doctor to come in and testify to the testator's mental state. That sometimes can help and is important, but this is one of the few cases where the courts allow lay witnesses. They allow me, who's not a medical doctor or a psychiatrist, psychologist, to make a determination that, yes, this person was of sound enough mind to make this will, and they let me actually testify to that opinion. Normally, in testimony, under the rules of evidence, testimony that is based on opinion can only be made by an expert in whatever area it is that we are discussing. So that is a very big exception to the normal rules of evidence that has developed in how we prove, and that's what we call the process, is proving a will, proving that it was the valid last will and testament. At the bottom of the first page on 14, some other terminology. Executor, executrix. In the will, one of the things that you do is you name somebody to carry out the handling of your affairs, of your estate. That person is called an executor if they're a male, an executrix if they're a female. In Massachusetts, now under the new code, this person is now called a personal representative. If you have no will and you have property, there still needs to be an estate opened, but now it is called an administration, and the person appointed is called either an administrator or an administratrix. All right, and they are appointed by the court, and there are various sundry and complicated rules about who can be the administrator, administratrix. In both Rhode Island and Massachusetts, the statute gives preference to family members, to blood relatives, but it's not necessarily only blood relatives. As an executor and executrix, you can pick any competent adult to be that person. They do not have to have any family connection to you. There are exceptions, a few exceptions to the rules for making wills. Some of them apply in Rhode Island, some of them do not. One exception is something called a nuncupative will. The word nunc in Latin means to pronounce, to say, to speak. So a nuncupative will is a verbal will. These are allowed only in very rare circumstances. Rhode Island allows for a nuncupative will to be made by a service person in battle at the front line who's in fear of imminent death. They can make a verbal statement to the people around them as to what they want to have happen with their estate. And if those people survive to testify and give witness verbal testimony about what the deceased soldier had said, then that will be allowed. But other than that, that's about the only exception that Rhode Island has to the rules for having a will that is written and signed by the testator. Many states, particularly as you get out west beyond the Mississippi River, allow something called a holographic will. A holographic will is a will entirely in the handwriting of the deceased. So the dead person sat down, the testatrix sat down, wrote out their entire last will and testament by hand, and then they sign it, and that becomes their last will and testament. I believe the reason that this is accepted out west is that you have to think about going back 150 years ago when they first settled the Great Plains and people were out in the wilderness in North Dakota, South Dakota, Montana, Wyoming, and all of a sudden you're alone in your cabin with no possibility of anybody showing up until the winter's over, and you begin to feel ill. There's no time to go get a lawyer and a witness to draw up a will that you can sign and go through all the formalities. You're going to sit there and scratch out what you can on a piece of paper, sign it, and leave it. And I really believe that because of those early social conditions, that's why these states allow these types of wills. They still allow them in modern times, and they have created some interesting things at times. There was a very wealthy businessman who was quite a playboy and had quite a magazine presence and periodical presence throughout the years of World War II and right after, called Howard Hughes. He became fabulously wealthy building airplanes during World War II. He was a billionaire when he died. He left no less than 4 holographic wills when he died. And he did not date the wills. Now, the law is clear that we will take whatever is the last will and testament, we will try and discover which one it is, and that will be your last will and testament, and that will determine what happens to your property. But if you have several wills and it is unclear which one came first, second, or third, then the idea is that you meant for all of them to be valid, and we tried to put all of them into effect. Well, needless to say, dying a billionaire with 4 handwritten wills undated floating around, Howard Hughes' estate made the lawyers tremendously wealthy, and I believe it took 15 or 16 years after his death for everything to finally be resolved. He died in the state of Nevada, and he kept the Nevada court system in business for a number of years after his death. If you want to change your will, you cannot change it by crossing out, by underlining, by cutting out a section. There is a great case from Rhode Island in the 1940s where a person had a will that was pages long. They listed a whole number of people they were leaving things to. And as they got upset with people as time went on, they would just take the will and they would cut out a section wherever that person was and destroy it. So when they finally died and the will came to be probated, there was this document that had all these holes in it where different people's names were cut out. The Supreme Court said that that was not a valid amendment to the will. Unfortunately, the lawyer who drafted the will had passed away by then. His office had been broken up. There were no longer any files or notes, because our court said you cannot change a will that way by crossing out names from the will, by cutting names out from the will, by writing in new things. You have to use the same formalities that first created the will to change the will. And our court said had they found all the pieces of paper, they would have glued them back into the will, and they would have probated it and told the probate court to handle the estate according to the way the will was originally written. So the only way to change a will is to create what is called a codicil, which is an amendment to the will. And the codicil must be signed by the testator. The testator must have capacity at the moment when they are signing it. It must be witnessed by 2 people, and the testator must see the witnesses sign. The witnesses must see each other and the testator sign. So it has to be done almost as a mini will. Now, one of the interesting things about codicils is if there was some problem with the original will's execution, and we now do a codicil that makes clear reference to the first will, saying, hi, this is an amendment to that first will. If the codicil is correctly executed, then that validates the first will. So it's kind of an interesting piggybacking arrangement that the courts have allowed for there. A will is not valid before the law until after you have died, because there is always a possibility you could have changed it or you could have revoked it. Revoking wills, we'll talk about that in a minute. When a testator dies, their will must be brought to probate court, must be presented to the court, and then the probate judge has the ultimate discretion to determine if this was a validly created will, and will it serve to handle the estate of the deceased. Now, when I first became an attorney, the witnesses to the will had to appear in court and give verbal testimony stating that they had gone through this little ceremony, they had gone through this procedure, and that they were the witnesses to the will. About 25 years ago, the legislature passed an amendment to the law which allows for something called a self-proving will. So now, after the will is signed by the testator and witnessed by the witnesses can sign another document, an affidavit, which basically says, hi, we are the witnesses to the will of John Smith. On this date we were here, we watched him sign, we watched each other sign, we believed he was sound mind and capable. They sign that is notarized, and once that is done, witnesses no longer have to appear. That document itself acts as the evidence needed to prove the will was properly executed. And of course, that has made the process much easier and simpler, because years after the fact, we don't have to try and hunt down the witnesses and find out if they're still alive, are they here, can they testify, will they testify. In Rhode Island, there are only two ways to revoke your will, and by revoke I mean to get rid of your will. All right? Number one, you can execute a new will which clearly says all prior wills, or this particular prior will, is revoked. In our format for wills, and I will put some sample a simple will up for you to look at on Blackboard. But in our will, the first paragraph always says that all prior wills are hereby revoked. So by making a second will, even if the second will just says, I don't want to have a will anymore, I want all prior wills to be revoked, that is the most clear way, the most determinative way to get rid of an older will, to make sure that's not somehow going to sneak in to be probated. If you destroy the will with the intention that is no longer your will, then it is no longer your will. However, we get into issues all the time where a party dies, they were in possession of their original will, and we cannot find it. Today, in our office, we keep paper copies of the signed will. We keep digital copies of the signed will. So just the fact that you ripped up your will at home in your den because you were mad at your heirs or your beneficiaries one night doesn't mean you're out of the woods. If you did not leave clear indication, or if you left a torn up will with a note saying, I destroyed this will because I no longer want to have a will, then that's fine. But if you just destroy the will, throw it in the trash, you die and we no longer can find it. If you did not tell anyone that you destroyed that will because you didn't want to be your will, the presumption is that it would still be your will. It just was mislaid, waylaid, or lost. And under certain procedures, with certain types of testimony, the copies of that will can come in and can be utilized as your last will and testament. So destruction of the will is not a very safe way to make sure that it is destroyed. If you make a will prior to marriage and you are married, then the prior will is revoked unless it was clearly made at a point when maybe you were already engaged and you already knew you were leaving property to the person you ultimately married. But if the will has no reference to your now spouse, then that will is revoked by the by the activity of your marriage. A divorce never used to terminate a will. And there were some horror stories across the country of people who had fought a long and bitter and horrible divorce, and one party finally won the assets that they wanted and then died a couple of weeks later, never having changed their will, and their old will from when they were happily married together left everything back to the divorced spouse. Rhode Island and a number of states, to prevent that from happening, have now changed the law so that if you write a will while you are married and then you subsequently get divorced, the divorce only wipes out any provisions giving something to the ex-spouse. Provisions about your children or other relatives or other beneficiaries stay intact, and the will itself stays intact. If you make a gift to a witness to the will is still valid, but the gift is void. So another reason why we insist that we are the parties who are the witnesses in our clients' wills. We don't want them to run into the situation they accidentally have a child or somebody they meant to leave property to act as one of the witnesses, and now by doing that they have taken that person out of the will. That person will get nothing. And person who's going to be an executor or a trustee under the will can also act as a witness to the will, and that does not void their nomination to that position, nor does it void the will. All right, we have 40 minutes. I think I'm going to stop there, and we will carry on with this.